On November 14, 2022, an incident occurred at an SKLD Wyoming nursing home involving a staff member named Sue and a visitor named Michelle. Sue, the administrator of the facility, called the police on Michelle, accusing her of trespassing and taking pictures of her mother without permission. Despite Michelle's claims that she had not committed any crime and that the nursing home was a public facility, the police quickly convicted her of trespassing and detained her.
She's not on the trespass list, so officially trespasser.
There you go.
Hello.
Hi,
Hello.
I'm Sue. I'm the administrator. So we have a family member who had an allegation against her, and so we've reached out to her and let her know that if she wants to visit, we need to meet with the team here and figure out a way we can keep the mom from being. Her guardian does not even want her to visit, but we talked her into letting her. If we do supervised or promise that she won't take pictures of her mom and put them all over Facebook and TikTok and stuff because the guardian doesn't want that happening. She came in, refused to talk to me, slammed the door in my face, wouldn't let me in the room. So,
You want to trespass?
yeah, at this point,
best
yes,
way to get her out of
until she will come in and meet with us and figure out what we
you
can
can always
do.
take the no trespass order
Because-
away, but
yeah.
let's get her trespass. That's the
Because
way
I don't
we're
want
gonna
to.
get her
I
out
don't
of
want
here.
to not let her see her mother, but she needs to do it so we can keep the mom safe.
During the encounter, Michelle argued that the nursing home, being publicly funded, should not be able to trespass on her without reasonable cause. She even mentioned contacting the facility's vice president, who allegedly stated that she had not committed any crime. Michelle believed that her actions were protected by her First Amendment rights, allowing her to visit the facility and take pictures freely. However, the police insisted that trespassing occurred because the nursing home, as private property, had the authority to restrict entry as they deemed necessary. They maintained that Michelle's refusal to cooperate and meet with the facility's team justified her trespass conviction.
Pretty much like anywhere, just like if you walk into a speedway, they can say, hey, I don't want this person here anymore. Doesn't matter what the reason for. If they tell me that, and they want you, they say, hey, I want them trespassed.
So when I come back tomorrow, I go to jail?
Yeah, you can't come back until you
I
figure it
will
out.
be coming back.
Okay.
And I already let the vice president and president, I spoke to them today. They said, we haven't heard anything. Well, then why are they doing this? You might want to call her.
Call them and tell them to talk to Sue then.
Correct.
That's the best you can do right now.
Yep, this is just I'm sorry, this is a fucking joke.
Yeah, I'm not saying you're wrong, but so don't come back on the property until you clear it up with the vice
I'm coming
president.
back tomorrow. I'll be here every day, and I don't care if I go to jail. I've already been told by lawyers, by the advocates that help Britney Spears. National News, the News 8, everybody's on this. So they've already told me, if you have to push the envelope, because that's just going to seal the lawsuit. Huh?
You're not going to be able to do that.
No, but it'll seal the deal when I'm getting arrested for no crime.
Okay.
Trespassing not be the crime.
No, but that's what I'm saying. They can't say I'm trespassing when I've committed no crime.
That is the crime. That's what we're trying to tell you.
Michelle expressed her frustration and stated her intention was to return to the facility, disregarding the trespass warning. She believed that her case had gained significant attention, citing advice from lawyers and advocates who had helped Britney Spears. She asserted that pushing the envelope and standing up for her rights would strengthen her potential lawsuit against the nursing home. Furthermore, Michelle claimed that one of the police officers violated her Fourth Amendment rights during her detainment. She alleged that he forcefully tried to seize her phone while she was attempting to inform her children of the situation. Despite not having committed any crime that warranted handcuffing, she was restrained by the officer.
I'm not going to see you.
Okay, well then you're going to be detained until we figure that out then.
Huh?
Then you're detained until we figure that out. And
Why are you detaining me?
Because right now you have to be trespassed.
Okay, well, can I make one phone call?
Nope, you have to give me your driver's license.
I
or
don't
just tell me your name.
Give you already know my name.
Okay, can you write down her name?
Oh my God.
Exactly how it's spelled.
So
until we can find you and we can figure out who you are.
Hold on, I'm going to
Exactly.
call and let them know, go pick up my kids, that I'm being arrested.
You're not being arrested right now.
Oh,
You're
yeah,
being detained.
So detained and arrested are two different things. Being
Hold
arrested
on.
means that you've been charged for something. Being detained is temporary.
Hold on, I'm being detained
Okay. Do you want to?
because I won't give them my license.
All right. So what's
I've
your
done
date?
nothing wrong.
What's your date of birth?
I've committed no crime.
What's your date of birth?
I committed no crime.
Okay, now you're being detained then.
Police officer.
And then we'll get a fingerprint scanner and then we'll figure it out. Let go of the phone.
Randy, you want to work with the police.
I'm not doing anything
Okay,
wrong.
right now, you need to
We're not
present
playing games with you.
Only
It
if
ain't
I've committed a crime
not
and
true.
reasonable articulable suspicion, and I've done nothing of the
So
sort.
right now you've been trespassed, okay?
Uh-huh.
So we need to identify you so we can
Uh-huh.
successfully trespass you by doing our lawful job.
Okay.
Michelle's perspective on the incident raises concerns about the staff's handling of her visitation rights and the violation of her constitutional rights by the police officers. She intends to take legal action, asserting that her rights were infringed upon throughout the incident. In yet another troubling incident that occurred on October 31, 2022, a visually impaired man named Jim Hodges was illegally arrested and detained by 2 Columbia County cops in Florida. The officers, Deputy Jamie Godey and Sergeant Randy Harrison, claimed that the walking stick Hodges had in his back pocket was a firearm, leading to his arrest without lawful authority. The encounter was captured on video by Hodges himself. When the officers approached him and questioned the object in his back pocket, Hodges explained that it was a walking stick. However, the officers insisted on obtaining his identification and detained him, citing their suspicion he was carrying a weapon.
There. What's this in your back pocket? I just saw you walking it.
It's a navigational aid. What's the problem? You a tyrant?
Yeah, I am actually. What's your name and date of birth?
I don't have to give that unless
Yes,
I'm
sir.
here.
I was
You
investigating.
have reasonable,
Do you want me to
articulated
put you in
suspicion.
handcuffs right now? Yes, sir, I do.
Hodges questioned the officer's authority and refused to provide his identification, stating he had not committed a crime. He asserted that his Fourth Amendment rights protected him from unreasonable searches and seizures without probable cause or a warrant. Despite Hodges' explanations, the officers continued to detain him and insisted on checking his identification.
Well, you're being one to me.
No, sir, I'm
Have a
doing my
good day.
job.
Am I detained?
Yeah, you are. What's your name and date of birth?
It does not matter.
Yes, sir, it does.
Do you have a crime?
Would you like me
Call
to
your
put you in?
supervisor,
He's right
please.
here.
All right.
You don't.
What's it stop for? For a walking stick.
So-
And it could look like a weapon. She asked you to really present it, okay? Now she's asking me for ID. Okay. I don't need the ID unless there's reasonable articulated suspicion that I have committed a crime, am committing a crime, or about to do a crime. Sir, and her suspicion was that you were armed, okay? And she's asking you for your ID. Well, now she has verified that I am not armed. Okay. So there is no problem. You have your ID or not? I do have my ID, but you don't need it. Okay. Okay. Sure, you do that.
77 Whiskey Mike 15. I don't know where his wallet is.
Where's your wallet at, sir? I don't have a wallet on me.
Okay, where's your ID?
Where's your ID at? Pocket. Which pocket? You are not allowed to search me.
It's in this pocket.
There you go.
Thank you.
The incident constitutes a clear violation of Hodges' Fourth Amendment rights, which protect against unreasonable searches, seizures, and false imprisonment. Florida statutes define false imprisonment as forcibly confining, abducting, imprisoning, or restraining another person without lawful authority and against their will. In this case, the officers wrongly arrested and detained Hodges, despite identifying the object in his back pocket as a walking stick.
It's gonna be. I want your name and your badge number. You know, I'll put you in jail for resisting.
Okay. All right, let's go.
I want your name and badge number too, sir.
Have a seat.
You wanna pick my property up, please?
I sure will, after you have a seat.
You wanna pull this out of my back pocket?
Sure. Here, I'll grab your jacket for you, too.
After an investigation by the sheriff's office, it was determined that Deputy Godey and Sergeant Harrison had violated several department policies. As a result, Sergeant Harrison was immediately demoted and suspended without pay for 7 days, while Deputy Godey received a 2-day suspension. Both officers were also required to undergo remedial training on civil rights. Hodges has retained an attorney and plans to file a lawsuit against the Columbia County Sheriff's Office. He's also requesting a federal investigation into the incident. The case highlights the importance of protecting individuals' constitutional rights and holding law enforcement accountable for any violations. In this next video, in May of 2020, an incident unfolded in Columbia County, Georgia, where a man was filming a video outside the store. However, the owners of the store called the police on him, prompting officers from the Columbia County Sheriff's Office to respond. The officer in charge approached the man and requested his identification, citing a call about his videotaping activity.
Yeah, we got a call about your videotaping
Yeah,
on their property. You haven't?
No, I'm not on their property. I never step on nobody's
Oh,
property.
okay.
No, sir.
No, I just got the call.
Yeah, absolutely. Yeah, I'm just letting you know.
Do you have a driver? Or an ID
Well, I
or
don't
anything?
show my ID. I don't do nothing wrong. You understand? I'm filming in public, giving people free advertisement, and they approach me. And if you could just tell them that I'm not doing anything wrong, and
But you weren't on the property.
no, sir, I'm very careful not to do that. I'll pull GIS surveys, and been doing this a long
What are you
time.
videoing for, if you don't mind me asking?
First Amendment, protected activity. Just
Just doing like
yeah, free advertisement.
Do you live around here? Are you from here? I
No,
don't see- I don't
I'm
recognize
not from
you
around here. Most people know me. I do this. I go around and,
Okay.
show people right from wrong, wrong from right. And, when they say they call the
Yeah,
police,
we
I
just
don't,
got a
I
call
don't
about
leave.
it.
Yeah.
Just checking on it.
Yeah.
But you were never on the property?
No, I'm very close. Never ever to do that. Matter of fact, far as I was right there at the edge of the curtilage, the GIS survey starts.
The man asserted that he had not committed any wrongdoing and explained that he was filming in a public area to provide free advertisement. He emphasized that he was careful not to trespass or infringe upon anyone's rights. Refusing to show his identification, he relied on his understanding of Georgia law, which states that unless someone has broken the law, they are not required to identify themselves. The officer alleged that the man had trespassed on the store's property, despite video evidence proving otherwise. However, the officer persisted in requesting identification to potentially charge the man with trespassing. The man maintained his innocence and questioned the basis for his detention, as he had not committed any crime.
Unless I've broken the law, you don't have to ID in the state of Georgia. Am I being detained?
Well, for the moment, yes.
For what crime?
Till we find out what's going on.
To what crime am I being committed?
We were called because you were on their property.
Right, and he determined I wasn't.
Okay.
Am I
Just
still-
hang tight for just a minute. We'll get you out.
Am I
of here,
being
okay?
detained for an unlawful reason? Yes or no?
Right now, you're being detained because you were on their property, and we're trying to find out what's going on.
Okay, and I can prove that I wasn't on their property, and they can't prove that I was. Or, there again, issue me a trespass, I'll be on my way, and then we'll go to court. But
A staff sergeant arrived at the scene, and the man recounted the entire incident, including his rights and the lack of any illegal activity. As the man spoke, the two deputies involved in the arrest stood by, seemingly embarrassed.
how are you? What was your name and badge number, sir?
Sure, it's Staff Sergeant Johnson, 93159.
Hey, Johnson. I was explaining to them, I'm out here exercising my rights, First Amendment right. Private property starts about 1.2 foot on the other side of that telephone pole per government document survey. Well,
Okay.
Anyway, I did my homework. I'm down here giving some people free advertisement. They called the police to me. This deputy here legally detained me for 18 minutes and 32 seconds for no suspicion of nothing. He told me that I had to show him my identification to be trespassed. I explained to him I was on the curtilage of that road. Right there, their property starts at the front tire of that VW.
Okay.
And I'm trying to exercise my rights. Both of them gentlemen stood in a auditorium or courthouse with their hand on a Bible, and they swore an oath to protect my civil rights.
Yes, sir.
He's wanting my Fourth Amendment violated. He's wanting my First Amendment violated. And they called the police to me and lied. I got 28 minutes of video that shows me doing exactly what I'm doing right now on public property, exercising my right as an American.
So
And
at any time did you go on their property?
No, sir. I look. He knows exactly who I am.
Which one?
To the left.
Okay.
And I told him I'm gonna file a formal complaint on him and him. And y'all have never ever had a problem with Columbia County.
Right.
Ever. And once you realize who I am and what I'm doing, and it really makes y'all look bad, man. And I'm illegally detained for no crime. That's a
Well, as long as you haven't been on their property, that's fine.
absolutely.
Because you're outside their property, and you're legally doing what you need to do.
Absolutely.
out
Can
here.
you explain that to them so they don't violate anybody else's
and
rights?
then they don't want you on their property.
Absolutely. And I don't go on
That's
their
why they were
property.
just saying a criminal trespass warning. So you've been warned.
I've been warned the first time that don't get an ID. The second time you do. See, he didn't know that. He didn't know that.
I'm good to go with you if you're.
Well, I'm good to go. Am I still detained? Thank you. Well, and thank you. I wait till y'all leave and then I leave.
The staff sergeant acknowledged the man's explanation and confirmed that he had not been on the store's property. The man expressed his intention to file a formal complaint against the deputy who detained him, citing violations of his Fourth Amendment rights and First Amendment rights. Eventually, the deputies conceded that there was no illegality in the man's filming activity and allowed him to leave without further detainment. This incident serves as a reminder of the importance of understanding and upholding individuals' constitutional rights, even during encounters with law enforcement.
The law is for everyone to follow, and no one is exempted from it, not even lawyers. No matter how intelligent they think they are, karma always gets them. Can attorneys get away with anything? Can they sway a ruling in favor of their clients or even themselves? Watch the video to see how these attorneys get owned by cops for breaking the law.
Las Vegas attorney in some trouble for a series of alleged late-night rendezvous with one of her clients.
Hal Uhrig, an area criminal defense attorney from Orlando, made headlines all over the country. Hal Uhrig, who represented George Zimmerman in the Trayvon Martin shooting incident, was arrested on various charges, which included soliciting perjury and tampering with a witness or victim. Marcos Lopez, Osceola County Sheriff, said that Uhrig took on a case involving a man named Krishnath Prasad, who had been charged of raping a 9-year-old girl. Uhrig was accused of holding a meeting with his client, the victim, and her father. Uhrig tried to cut a deal to keep the suspect from going to jail. During their meeting, Uhrig instructed the victim and her father to do 3 things. Firstly, to write a declination, that is a letter to the state attorney saying that the rape never happened.
Basically a letter to the state attorney saying the rape didn't happen.
Secondly, to avoid being served a subpoena so that they didn't have to go to court to testify, and lastly, to lie during their deposition and say that the rape didn't happen. According to Lopez, he wanted to make sure this guy didn't go to trial for rape. He added that Mr. Prasad committed the sexual battery at a time when she was 9 years old, and this is what caused Mr. Uhrig to work a deal out with the victim to try and get Mr. Prasad off on a lesser charge so that sexual assault battery cases will go to trial, and this will be a separate trial against the attorney. Even after being pressured to such an extent, the victim decided to come forward and report the conduct to the state attorney's office in July of 2021. Osceola County started an investigation against Prasad's attorney on the basis of the victim's complaint. The victim's father engaged in a controlled phone call with Uhrig and said that he couldn't talk on the phone about any specifics and wanted to meet in person. According to the officials, the father wore a recording device during his meeting with Uhrig, and during the meeting, the attorney made him turn off his cell phone and told the father to read a script off of his computer screen.
He wore a recording device, the victim's father. During the meeting, the attorney made him turn off his cell phone.
Lopez said that the script was his defense for when he goes to court on the charges. However, fate had other plans for them. Prasad, who was arrested back in 2019, is working his way through the court system. On the other hand, Uhrig is accused of soliciting to commit perjury, which is a third-degree felony, and also for tampering with and harassing a victim, which amounts to a capital life felony. Given Uhrig's 40-year-long career, this might not be the first time he has done something like this. According to Lopez, if you're an attorney, you've been practicing law for a long time, and there's no way you're going to jeopardize your career on something like this, especially at that age. Especially at that age, it's retirement time. So I think this wasn't his first rodeo. Unless someone else comes forward, we won't know that, but that's what I suspect this time. The next attorney in line is Alexis Plunkett. This topsy-turvy case involves a 38-year-old attorney from Las Vegas named Alexis Plunkett, was indicted with 2 counts of conspiracy to unlawfully possess a portable communication device and 12 counts of a portable telecommunication device by a prison. The charges relate to her visit with her 28-year-old client and boyfriend at the time named Andrew Arevalo. This man was shot in the face by a high state correction officer in 2014. He also faced felony and weapon charges and was awaiting trial. His case was represented by Plunkett in his lawsuit against the Nevada Department of Corrections in connection with the shooting, which resulted in another man's death. During her visit, security camera footage shows Plunkett handing over her phone to Arevalo. Now, this is a felony that could land her in jail for a year. However, her case took a complicated turn. Even though the couple started off as boyfriend and girlfriend, they were experiencing rifts in their relationship after her phone was examined by the police. It seems that she is trying to put a hit on Arevalo. Her text messages about her joking about felonies led her to her downfall. Some of the texts read, I've placed hits in every Nevada prison on Andrew with every homie and lifer I know. She further added, this pause will never survive in prison now. He's F with the wrong bit. I am not the one. I represent all the sure knows and he's gonna get it. However, one of the people in the group asked her to delete the message. He said, Alexis, this isn't funny. I know you are under a tremendous amount of stress, but I'm not interested in joking about felonies. I don't think anyone is either. She replied, I am not joking. That's why I said to delete it. He said he was going to have me murdered, so I'll take care of business first. Plunkett's attorney Adam Solinger said that her messages show that she was under great stress and she was only venting about the bad situation she was in and that her words shouldn't be taken as a serious threat. Despite all of her 14-count indictment, Plunkett was dismissed by the district judge Michael Villani. However, she was shockingly arrested again for charges of bribing or intimidating a witness, which is a felony. According to her lawyer, her guilty plea comes after reaching an agreement with prosecutors. The agreement is a good resolution for all sides involved. It's the choice that she made that's best for her, and I respect that. Ultimately, it came down to being tired of continued litigation. Fighting a war on two fronts takes a toll on you, and remaining in custody pending your trial and resolution of your other case is really hard to do. She pleaded guilty of possession of a telecommunication device and was ordered to serve 3 years of probation and was later disbarred. In the next case, Christopher Reynolds, a 44-year-old Florida attorney, shocked everyone. He was accused of stealing nearly $800,000 from his clients. He was arrested by the Pinellas County Sheriff's Office for multiple charges, including money laundering and grand theft. He started his private practice in Seminole back in 2015, representing victims of vehicle crashes. He had dealt with at least 16 clients before they had their money stolen by Reynolds. It was back in October that the detectives came to know about the theft when one of Reynolds' clients came forward. The client complained to the authorities that her lawsuit for $100,000 had been settled months earlier. However, Reynolds never notified her about this. The investigators made a shocking discovery. Reynolds had forged his client's signature on the legal documents and collected the money from insurance companies that should have been disturbed to pay medical bills and provide other compensation related to car accident. This was a similar pattern for most of the clients that had availed his services. Once he had settled his case, he would disappear without a trace, never to be seen again. He would neither pick up the calls or respond to the voicemails and would cut off all forms of communication he had with the client's eye. In another incident, the lawyer pocketed the woman's $100,000 and continuously lied to her in the communications before it abruptly stopped that he was going to solve this with the insurance company. He also forged the woman's name on settlement documents, and he never paid her medical bills with the settlement money. His highest theft amounted to $148,750 from a client back in 2019. Sheriff Gualtieri claimed that the clients must have had serious injuries for their settlement money to be in 6 figures. Now, what did he do with the money he stole? The answer will shock you. The lawyer had a drug abuse problem. He used a portion of the stolen money to purchase drugs and nearly spent $30,000 on pornography and $424,000 on prostitution. Sheriff Gualtieri later commented, "They're licensed to practice law. They've got the boxes checked. They've got the credentials. They've got the credibility that goes with that, and they're really just a thief who is ripping them off." These are not isolated cases. Many lawyers who are corrupted and have been cheating people for years are roaming free in this world with no one to put a check on them. What do you think of these lawyers? Were they punished approximately? Let us know your thoughts in the comments below. Don't forget to press the bell icon and subscribe to our channel for future updates.